pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Honor the Texas flag. I pledge allegiance to thee, Texas, one state, under God, one and indivisible. Happy birthday to you. Happy birthday to you. Well, happy birthday, dear children. Happy birthday to you. Thank you. Many more. Thank you. Every birthday is a blessing in my age. Let me tell you. Thank y'all so much. Before we get started, last night, all the grandkids were sitting there waiting to play Uno. And they finally said, "Man, how old are you going to be on your birthday tomorrow?" I said, 69. And Corey Lynn, the little one, said, "Wow, that is old." It is old.
Ain't that old in the club?
I tell you what, it sounds, all the ages sound different as you get older. I used to think 30 was old.
Did you know that now, since we have is it Facebook, not Facebook, everybody in the whole county and the whole place knows exactly how old you are.
That's good, because they probably thought I was old.
All those days you were saying you were 45, you know,
yes, yes, in a way, in my mind, I'm 45. In my mind, I'm 45.
Happy birthday.
Thank you.
She's still red on that.
Still what? Y'all are so sweet. Thank you. This meeting will please come to order. Do we have proof of posting in accordance with Chapter 551 of the Texas Government Code as amended, known as the Texas Open Meetings Act? Yes, ma'am. Thank you. Do we have any members of the public who would like to speak? That's just Buck back there, so. All right, we'll go right on to number 1 to approve the minutes of the December 13th regular meeting.
On number 8, that confusion between buy board and gov deals, we need to take out the gov deals. That is where we are selling assets. Buy board is where we buy the assets.
Take out gov deals, correct? On the body of the motion.
Yeah, it says to purchase equipment through gov deals buy board. Take gov deals out and just say
Gov
through
deals
buy board.
We can't take it out in the top part because that was actually the way that was supposed to, but take it out in the bottom.
Do that.
Correct.
Well, we talked about that before.
Well, right, but it accidentally got into the motion part down there. We didn't need that. Okay. I'm glad we clarified number 6, that we wanted that to be kind of confidential.
Does that sound good the way that is?
Pardon?
Is that good the way that is?
Yes, no, I was just laughing about us talking about it being kind of confidential and it being on Facebook, as we said, yeah, so we know how confidential that is. Do we have a motion?
I'll make a motion that we approve the minutes with the,
One change.
change.
Okay, we have a second with that change. All in favor, aye. Any opposed, none, motion carried. Item number 2, budget transfers and amendments.
I supplied the court with a list. We have transfers as well as an amendment that is attached. That's for the $5,000 that was the donation to the Sheriff's Department. And I must certify to the court that we have received that $5,000 to support the donation and amendment. Thank you.
All in favor, aye. Any opposed? None, motion carried. Item number 3, approve pay bills. Any discussion on the bills?
I make a motion that we approve paying the bill.
I just have one question before you done. On page 27, it says precinct 4, Road and Bridge precinct 4. And I spent $257.21, and under that says grand total $29,437.98. What's that? Anybody know?
That's the total of the bills, the total of all of the bills.
Oh, that's not my bill, right?
No,
Okay. I don't know how these guys are.
no, that's the total of the bills without the one add-on
Okay,
that we've got.
okay.
I think somebody charged us a year.
That's what I was thinking. We just fixed it clear. Thank y'all. I'll second your motion.
That's good, that's good. Okay, thank you so much. All right. Now we have a motion to approve the bills.
No, I second it, just a minute.
Thank you. All in favor, aye. Motion carried. Item number 4 is to approve the payroll. The only change is Sheena Wimberly was moved to jail administrator.
They'll make that motion.
Second.
All in favor, aye. Motion carried. Item number 5 is reports. I have a report from the auditor's office, the monthly report for November. And based on that monthly report, we have the county treasurer's monthly report that is to be placed on the website. Anyone else have a report?
I have one additional, Ms. Grant.
All right.
This is our annual DMV policy check, where we take the list of drivers furnished by the elected officials and department heads. We run them, their driver's licenses, and compare them against our point system, and everybody passed is eligible to drive the county vehicles.
Did you give me the treasurer's?
I'll get their sign. Thank you. All right, if there are no more reports, do we have a motion to accept the reports?
Make a motion that we
Second.
Thank you. All in favor, aye. Motion carried. Item number 6 is to discuss the engagement of the Beckham Group for opioid litigation. And Patrick Shan is going to visit with us about that this morning.
Judge Grant, do you mind if I pass these out?
Sure.
These are just pretty small notebooks, but I thought I might leave them with you. I emailed these to you and Ms. Harris, so if someone would rather use electronic copies, you forward them.
All right.
Thank you, Judge Grant and County Commissioners, for putting me on the agenda. I've talked with Judge Grant several times, and we actually, our law firm out of Dallas, the Beckham Group, have done some work for the county. We filed some documents for the county in the fight against the high-speed train. The Beckham Group, our law firm, and my boss, we are special litigation counsel for Texas against high-speed rail. And for about 2 years in federal courts, state courts, the Surface Transportation Board, the Federal Railroad Administration, we have been doing everything we can to try to stop the high-speed train. We also represent, right now, I believe around 150 landowners up and down the affected corridor. My boss, Blake, has property here in Freestone County. It actually straddles the Freestone County, Limestone County line. And by virtue of some of the relationships that we've made with the county commissioners and county judges, we have now gotten into this opioid litigation. We're partnered with a couple other attorneys that specialize in these mass tort type cases. And to be honest with you, before we started working on this, I wasn't really aware of how big a problem the opioid epidemic was. And now I am. So what I'd like to do is just briefly tell you a little bit of background about it, and then the rest of the information's in there, and so I won't keep you too long. But just to give you a little idea of the scope of the problem, President Trump recently declared it, the opioid crisis, an emergency health crisis. And the Center for Disease Control, the CDC, has done quite a bit of research on not only how bad the epidemic is, but also what it has caused damage-wise to counties and states. And the most recent report, which is probably undershooting it, estimates it at about $79 billion in cost to counties and states. And those come from 3 different things. One is your healthcare costs, your hospital costs. 2 is your law enforcement costs and criminal justice costs. And 3 is your loss of worker productivity. You have a lot of people that stop coming to work, they get fired, that sort of thing. Right as of 2012, there was 259 million people, prescriptions written for opioids in the United States. Just to give you an example of the magnitude, right now in America, there's 31% of Americans use tobacco. 38% of Americans use prescription opioids. And I had no clue it had become that pervasive. And the reason is that it used to be opioids would be prescribed for 3 different reasons. One would be palliative care. If someone was at end of life, in pain, they would prescribe them. 2 would be for people who had progressive, painful forms of cancer. And the 3rd would be, for instance, if you were to break your ankle skiing and the doctor needed to get the boot off and the patient is screaming and yelling and in pain, under the supervision of a doctor, they would give them some sort of opioids where they could get the boot off and operate and take care of it. Well, what happened was these pharmaceutical companies started using a lot of deceptive advertising and distributing literature, and they convinced the medical community and doctors and these patients that these drugs could be prescribed for chronic pain, whether you have arthritis, things of that sort. Your manual laborers who would have back pain, things of that sort. But these drugs are so highly addictive that they say that for a lot of these drugs, you can become clinically addicted in 4 days. And so you have a problem not only on the front end of all these people using prescription opioids, but also 80% of the heroin users in the United States started by using prescription painkillers. And what happens is that they start using prescription painkillers, and either they run out of money or their health care doesn't cover it, and then they find someone that says, well, here, you can, heroin's a replacement for that, it's cheaper, and the cycle continues. In Texas, between 2008 and 2014, there was about 9,000 opioid overdose deaths, and the statistics say that for every death, there's 30 non-fatal overdoses, where you have to give them these Noxolin shots and put them in treatment, and it is extremely expensive to cover opioid addict costs. They say it averages for someone who takes prescription painkillers, their healthcare costs on average are $11,000 more per year than someone who's not addicted. So we got involved with this litigation, and the group that we're working with is County and Greenstone, and they already represent, I think total, we represent 26 counties in Texas. And the deal is simply this: it's a 30% contingency fee, and unlike most contingency fees where the client will front the expenses for experts, copy costs, court reporters, travel, whatever, this is, we're covering all the expenses. So all the experts, all that, the county is not responsible for anything. They're not going to receive a hourly fees from us each month. They're not going to receive any invoice for expenses. It's just simply, if we end up recovering money from the pharmaceutical companies, we keep 30%, 70% goes to the county. Now, the importance of acting fast on this is that the state of Texas has not yet filed one of these cases. They may. They have looked into it, but they have not yet done it. But if the law says if the county files first, then even if the state files after, the county can control their own litigation. You can move forward, you can determine if you want to settle, move forward, and control your own litigation. And I think that's important because I think it was 5 years ago, or maybe further than that, the state actually settled with one of these manufacturers. And it was a big settlement between a lot of states, and I think Texas received $29 million of that settlement. Well, I doubt any of that was passed down to Freestone County. And so, you know, Texas may bring a suit, and if they do, they may recover quite a bit of money. But the chances of that getting passed down to Freestone County, we believe are slim. The two main claims is a public nuisance claim, which simply means that these drug manufacturers have placed a dangerous condition on the public at large. And the second is a violation of the Controlled Substance Act, which means that in a lot of these instances, these pharmaceutical companies have been pushing these drugs knowing that there's no valid reason for pushing them. And we don't know yet exactly how we're going to quantify how much, for instance, Freestone County's been damaged. We're getting there. We do know each of the counties have been damaged. And we don't know that we're going to be able to recover all of your damages, but we think we are going to be able to quantify it to some degree of certainty and be able to recover. And there are several other groups that are doing this type of litigation, and they can speak to you too. As far as why I think if you guys are interested in pursuing this litigation, you should choose our group than the others. As one, I think that Judge Grant, Judge Ben Lamont from Grimes County, Judge Byron Ryder, a lot of the commissioners we work with, you can call any of them and they'll vouch for our legal work, and they'll vouch for our honesty, and I believe that we've built a reputation in some of these counties as being good attorneys and definitely looking out for the best interest of the counties. And the second is I think a lot of the other attorneys will tell you about what they're going to do for you. We're going to hire these people. We're going to file these cases. Our group's already done that. So I can tell you about what we are doing, which is we've hired the experts we need. We've got them retained. We filed cases. We filed federal court cases. We filed state cases. We are way further along the curve than a lot of these other groups. And I think in the end that's going to pay dividends, because if, to the extent these companies are going to settle and pay money, you don't want to be the ones at the end of the line. You want to be the ones up front that are pushing it from the front. And in the book that I gave you, there's 4 things. There's a PowerPoint that explains a little bit of the background I just told you, and it gives you some statistics. There is a memorandum in there that explains why it's important for the counties to file before the state. There's one that gives the legal support for the claims. So if you're wondering, well, how is the county able to bring these claims, it explains that. And then the fourth document in there outlines some of the settlements that have been reached in other cases against some of the pharmaceutical companies by counties and states, so you kind of get an idea that people have had success bringing these cases. And then the last is just a copy of the fee agreement, which I also have just stapled clean copies if you'd like to see those. So that's all I have to tell you today. If you guys have any questions about it, I'd be happy to answer them, but I hope you consider engaging us for this, because it really is, I see it as a nothing to lose situation. We may do good, we may do really good, and we may just show back up and say, here you go, here's your portion of the check. Of course, we'd keep you guys informed, and you'd be able to, we'd advise you of how things are going, and if there was any settlement proposals, and you guys would be able to make your own decision on that.
Did you have any case, 60 Minutes on Sunday night?
I
They
watched
did their 20-minute segment on this.
Yes.
Totally amazing. Totally amazing.
Well, and I'll say this, a lot of these cases, you get to them and you're saying, well, how are we going to dig up the evidence of what these pharmaceutical companies did? Well, that portion of the case of liability, I think, is a laydown. I mean, what they did to essentially lie to the doctors and lie to these patients about how this stuff was not addictive, it's egregious, it's documented under oath, and I think the worst thing that they did, and to me it's just unfathomable, is that after some of these pills became very addictive, and what was happening is that patients were experiencing withdrawals. They'd take them, and then they'd need more of them, and they would come to the doctors, and they'd get pretty aggressive and say, I want this pill, I need more of these pills. Well, the medical community tried to deal with that. They created a term called pseudo-addiction, and they convinced the doctors, well, these patients, they're not actually addicted. They just think that they're addicted. And the way to treat that is, the problem is that they're actually in pain. And that's why they're coming to you aggressive. So the way to treat that is to prescribe more and up the dosage. And to me, under the circumstances and them knowing how highly addictive and the damage this was causing, it's pretty egregious conduct. And so we feel very good that the tide's kind of turning on this, like you said. It's on 60 Minutes. President Trump's talked about it, and I think that once the light gets shined on it and the tide turns on it, there's going to be hell to pay for these pharmaceutical companies.
Yeah, because they're supposed to keep records, and any red flag that might come up, and they don't do that.
No.
They don't turn in anything.
No.
You send 100,000 pills to a mom and pop deal every month in a town of 1,500 population. That ought to throw up some kind of...
Right, and that's what, they term those, there's some doctors in some of these, some towns, they call them pill mills, and that's what they do. And so, and that brings up another point as far as whether the cases get filed in state court or federal court. All these pharmaceutical companies are out of state, so if you're just suing the pharmaceutical companies, your case is going to be in federal court, and that has its advantages and disadvantages. If it's determined that there is one of these pill mills, either in Freestone or Limestone or one of the neighboring counties, that is serving Freestone County, and you can name that doctor, then the cases are filed in state court. But we have not, we're very careful about, we're under no circumstances would we file against a local doctor or pharmacy in order to get in state court. The only times that we've done that is when there is a notorious pill mill doctor that has been doing some real harm. So that's kind of our stance on that.
I think we probably should look at our information,
Okay.
talk about it a little bit, give this to our attorney and let him, if he has any questions, talk to y'all, and maybe we can table this to next week and see if he can come back, and if there are any other questions, we'll then we can address them to him, would be my recommendation, unless y'all are ready to make a decision today.
I just ask a question.
Sure.
That on 60 Minutes was about that one company, pharmaceutical company, McKesson. Are you going after all pharmaceutical companies?
Yes, McKesson's one of the larger ones, Purdue Pharma, they're the ones that produce OxyContin. But there's quite a few, there's a list of them in the engagement agreement that says claims or potential claims against these folks that McKesson's definitely.
Okay, and then the other question I had, when the state of Texas filed a suit against the big tobacco companies, and we get a tobacco settlement out of that every year, what's the difference in the state of Texas filing one versus us going with an independent firm?
Well, if the state of Texas files one, like I said, they would control the litigation and the settlement and whatever benefits that Freestone were to receive. That over time would be what they receive, but it would be completely out of Freestone County's control. Now, if Freestone County filed on its own and were able to come to a settlement zone, it would be able to recover those monies, and then if the state were to file and those monies came down from the state, then it would...
It'd be two different suits?
It would be. And I don't know what the state is going to do. We know that they're looking at it, but they have not taken action. And for the counties that we're representing, it has been our advice to them, and we are doing it as soon as we get engaged, we get the lawsuit on file. Because we want to file before the state. And just out of our counties, I think we already have about 25 on file.
What's the filing before the state?
It's, well, there's the legal rules related to jurisdiction say that the case that's filed first, under those circumstances, has dominant jurisdiction. So unless there's a few exceptions, that case gets to go forward. If the state filed first and then the county filed, the county's suit would be evaded. It would be stayed and it would not proceed because the state was proceeding. So if it goes the other way, then it gets stayed. If you file first, then you can go forward.
Family live around over here.
So let's table this to next time, and then we can hopefully decide to go forward. How are we going to?
Sure. You have my contact information, and if you want us to speak to the county attorney, we'd be more than happy to.
All right, we'll give him one of these books, and your information is in here, isn't it? I have it if it's not, but,
I believe so.
okay. All right.
Thank you for the time.
Thank you for coming, thank you. And you're certainly welcome to come back next time, or if you'd like to just speak with him, over the phone, I think we'll be
We
fine.
can do that.
If we have any questions, and he can address them to you.
Thank you so much.
And everybody can review their book. And do we have a motion to table?
Make a motion that we table.
Second.
All in favor, aye. Motion carried. Okay. Thank you for coming. You're welcome to stay, but if you need to leave, I understand.
Okay, I want to hit the road. Thank you
Sure.
guys, I really
Thank
appreciate
you.
it.
Thank you.
Item number 7 is the appointment of a health authority for Freestone County. Now, our health authority has been Mr. David Latham, and he has agreed to continue serving.
Make that motion.
Second.
All in favor, aye. Motion carried. Item number 8 is appointment to the Heart of Texas Housing Finance Corporation Board of Directors. And the Heart of Texas Housing Finance Board. Find the name. I'll read you a little background on the board. The board was formed in the early 1980s as a way to help create financing for targeted areas. The board holds 4 voting members appointed by the City of Waco, and 3 voting members appointed jointly by the McLennan County, Bosque County, Falls County, Freestone County, Hill County, and Limestone County group. In order for the county's appointment to become a voting member, all 7 counties have to approve the appointment. Please note that this is not a hot hog related board, but a separate individual board. And McLennan County wants to appoint Yancy Martinet, and they are asking for us to approve their appointment. Four members are appointed by the City of Waco, and 3 by the other, by the counties in our region. But in order for any appointment to be made, we have to approve it. So, do we have a motion to approve the City of Waco's appointment?
That's what I'm looking.
I second.
All in favor, aye. Motion carried. Let me be sure I stated that right. Actually, I did not. Yes, I did. Let me restate it. This vacancy is for a director that is jointly appointed by McLennan, Bosque, Falls, Freestone, Hill, and Limestone. And the McLennan County Commissioners Court approved the appointment of Mr. Martinet. So they are asking us, as one of the counties in the region, to approve that appointment. I may not have said that exactly correctly before. And we have a motion and a second. Is that your motion?
Yeah.
And second. All in favor, aye? We already voted, but motion carried. Thank you. Now, item number 9, amend the employee handbook. There are several things we're going to need to be talking about over time. The one thing that I really wanted to talk about right now is something that was sent to us from TAC. And in order for our policy to be in compliance with the law, we need to add, and this must be something that has changed, because it was in compliance when they first sent us the employee manual, and now they are asking us, I don't know if this is something by the last legislature or just a clarification, but the part that they want added, or recommend that we add, is under drug and alcohol, all employees. Any employee who admits to drug use may be terminated. An employee who voluntarily asks for time off to get treatment and recover from a drug or alcohol abuse problem will be given protections as required by law. Upon returning to work from a bona fide inpatient treatment facility, the employee will be subjected to a volunteer drug testing program as often as monthly until there is evidence the employee no longer uses. Failure to comply with the requirements of the post-rehabilitative program, including refusing the volunteer testing program, will result in termination. The post-rehabilitative program will last for as long as 2 years. At any time the employee tests positive or refuses the volunteer drug test during this post-rehabilitative program, the employee will be terminated.
Mrs. Grant, I'm gonna make a comment right here.
Okay?
Us as commissioners knew absolutely nothing about this being on there, other than we're here to make a decision today about that.
And
We knew absolutely nothing about it. I'm gonna speak for me. I knew absolutely nothing about it, other than on the agenda that I got, it said we're gonna talk about the handbook. And and we're asked to make a decision on something today.
No,
This-
not today necessarily. I'm reading to you what it is, and then that's the recommendation. We can table this to next time, just like we do other things.
Because I mean,
And
I'm
you
not,
can-
I
you
can't
can
make a
read it.
decision on all, I can't cipher all that in 5 minutes. That's
Right.
just me, and that's the way I am, so.
Okay, and then we had one other thing to talk about, but we certainly can at any time table it and talk about it at a later time, when we've had time to think about that.
Can I say something about that?
Yeah,
I don't have to think about that. If they doing drugs and work for the county, we don't need them. I'm not gonna have them.
And so,
Y'all do what you want to.
and so now then, we're coming up with something, we've asked several times about having our road and bridge employees get tested because they're, I mean, they get tested at random because they have CDO license.
Correct.
We've asked many times about why we couldn't randomly test all the county employees. And we've been told by TAC and by other people, we can't do it. And now they're coming up with something, well, if you do this, you do this, and you do this. I think I need a whole lot of time to cycle. This is just me. I need time to cycle that.
and I do want to table this to next time, because I want Brian to talk to us about that other part, about the random testing. That was the next part of this. We did get some more stuff from TAC, which talks about how you can randomly test current employees. But I think Brian needs to talk to us about that. So we have those two, and then there may be other things that we would want to talk about on the employee manual.
In tax, is TAC the
Texas Association of
I understand.
Counties.
I'm very familiar with that.
I know
But
you
are they the ones that tell us what to do? Are they make decisions for our county, or they just assure that we follow the law?
They send us things that they recommend, because it comes from anything new or any new changes in the law, and they make a recommendation. We don't have to put any of it in.
Right.
I know.
No, but that's just the recommendation based on either changing cases that have come or the legislature. But they are, and I'll read the recommendation. Not even a recommendation, I guess it's just information for us to consider. If I can find that. But you know, as with anything, a lot of times we'll start off talking about something and we know, but we just need to get the conversation started.
I need to know about what the conversation is before I can talk about it.
Well, that's what I'm telling you the conversation is, at this point is, to talk about this change in addition to the policy, this addition, and then Brian will be talking about the other part of, let me read to you what it is, if I can find it, right here.
So it only has been that the employees with CDL are the only one in the past that was tested?
We have a pre-employment requirement where we can test people prior. When you are going to hire somebody, you say, I am offering you this job subject to you passing the drug test and the background check. Once you are employed, we cannot legally test someone unless it's for CDL purposes, unless there is reasonable suspicion.
That's not good.
But that's the law.
Yeah, the law.
The law.
Did we just have to get all of our licenses and everybody drove a county car and have pictures made again?
Yep.
Yes.
I think everybody that drives a car, anything ought to be tested, red random.
We think that, but by law, we can't do that.
Yeah, I don't understand.
I understand that. There's a lot of things the law is not
I know what
right.
you fixing.
But I'm just thinking, if you have a county employee that is on drugs, whether they're driving a car or not, something happened to them because they're on drugs, and then they turn around and try to sue the county. I don't understand, how could that be the law that you cannot be randomly drug tested? I don't
Well,
understand that.
We've talked about this before too, and for your information, let me, and yours, Andy. If you believe there is a problem, then you're supposed to talk to the county attorney. And if there is reasonable suspicion, then you can require them to take a drug test. But you can't just randomly test an employee.
So if today I got to work and I reasonably thought that one of my employees was intoxicated, I could not take that employee, I could not get with somebody else and say, I think he's intoxicated, and I could not take him down and have a drug test or an alcohol test. I couldn't do that. I gotta go to the county attorney. He'll be sober by then.
The reason, Judge, that they said that before is because there's certain legal procedures to follow when, and I don't know about y'all, but I don't know what they are, and I wouldn't want to take that
Well,
responsibility.
TAC has come up with something new, and this is what we will be talking about next time. They are saying that we should, if we want to put this in our policy, that we would have to require, or we should require supervisors to be trained. And the training is under the influence or reasonable suspicion. And the reason right now that we ask, if we think it is a drug problem, now alcohol might be a little bit different because it does dissipate quickly. But so that so that the county attorney can be sure that your reasonable suspicion, I guess is considered reasonable suspicion, to keep the county from being sued for us testing somebody just out of whim. Not out of whim, but I mean to be sure that we are legally within our bounds. This is what they describe as reasonable suspicion. And we can put this in our policy.
But you gotta
If
follow
we
it.
choose to do that. Pardon?
You're gonna have to follow it. And that's what TAC's got an interest in it, because they're gonna be the ones to represent us if we just snatch someone up and say, we're taking you down there and you're taking a drug test, and we didn't follow all the proper procedures.
Well, and also, when you take them down there, you have to have somebody carry them down there. You have to take them down there, you have to drug test them. Then you have to bring them back to work. Then you have to provide them transportation home, and then you have to get their vehicle home. If you follow the way the rules are supposed to be, you'll have to provide all those things. Take them down there, bring them back, make sure their car gets home, make sure they get home, give them whatever the procedure is a day or two off, and then they can say, I'm sorry, I'm addicted to drugs, and then you go through the whole process. There it is.
If we should elect to put this in, suspicion-based testing, it says at the bottom, elected officials or supervisors must take action if they have reason to believe one or more of the above listed conditions is indicated, and that the substance abuse is affecting their employee's job performance or behavior. And then it gives the steps. So I'll give you a copy of that, and then Brian, I think, will be talking to us at the next meeting about these issues.
I'm just kind of surprised that they just don't have just like they do the one with the CDL, just have a random drug test. I mean, I worked there, they just to go through that, and it showed up at work, so we drug testing you today. And I just don't understand that. That's a little confusing too.
And he can talk to us about that too.
I make a motion that we table it.
I second it.
All in favor, aye. Motion carried. All right. Burn ban?
I'll make a motion to take it off.
I'm a second. Well, let me ask a question. Are we having a meeting next week?
I don't know.
We are not paying bills next week.
We don't have a payroll.
So, the reason I'm asking if we take it off, and then have a week to put that on next week. I second what you said.
You second the motion to take it off? We have a motion and a second. Any discussion? All in favor of taking it off? Motion carried. If it,
I'm not in favor of putting it on, taking it off every other week.
No.
Maybe it takes too much hand to
Takes
what
too
turns
much.
by.
Yeah, we'll do that for a couple of weeks.
So it'll be on 2 weeks for sure.
Yeah.
We don't have a
it'll be
meeting.
on the, it'll be
We're
on.
not gonna have a meeting next week.
I mean, it needs to be on the agenda every
I don't know,
time.
I just heard them say that.
Yeah, we don't have to, they ain't got
I
no.
mean, y'all can still have a meeting, but she doesn't have any bills and I don't have any payroll, so it's up to y'all.
So unless somebody requests, we will not have a meeting next week. Do you need one? Well, then these two things that are tabled will be on the meeting the week after that. Okay? Special road use agreements. No, I have one continuation bond, and it is for Jeannie Keeney in the treasurer's office.
Second.
All in favor, aye? Any opposed? None. Motion carried. Comments from Commissioners Court?
I'd like to commend Mr. Daniels on his church at True Vine. He did a good Christmas get-together over there at the church, and our law enforcement that showed up appreciated the breakfast that he had for us that morning. So thank you, Mr. Daniels. And I would also like to thank the entire Commissioners Court because our new vehicles rolled out yesterday. So they hit the street, they're nice. They were under the 200,000 that we expected them to be, and so we appreciate it. Thank you.
Right.
Can I make a comment? I am looking into possibly issuing passports, and I would like the court to know that I have not spoken to the judge, but my plan was to speak with you today if possible about that. Another thing that is, I guess, a good insight possibly, as far as our elections are going, is the reimbursement for county chairs. We've been told that a lot of the big bills are going to be being sent straight to the party chairs due to the state, so we have some money in there that the county needs to realize that will be sitting there unless it's needed for something else this year.
All right. Anything else? If not, we're adjourned.